Chair.
Okay, Senators, just a bit of organizational procedure. So, as indicated, we would take the remaining clauses in batches, as we have been doing. And what I will do is, as we treat with the batches, I would ask Senators to identify the particular clause that they may have amendments to within the batch. So we completed, by way of procedure, clause 65, and within that batch we have clause 66 and 67 remaining.
Yes, well, 67 is here, sir. Clause 67. 66, sir. Mr. Chairman, where are we?
66 and 67.
Yeah.
One second, the clerk has to announce.
Yeah.
Clauses 66 and 67.
Okay.
Yeah. Mr. Chairman.
Senator Mark?
Yes,
what?
thank you. Thank you very much, Mr. Chairman. Mr. Chairman, in terms of clause 67, subclause 2 or section 2, we would like that entire section removed from the legislation. We did, in fact, pursue this matter elsewhere, and we had been given an undertaking that it would have been addressed in this House by the Attorney General. But having regard to what he has already indicated, I would suggest that we put it to the vote on this one.
Mr. Chair.
Okay, so just to clarify, 67.2, you're proposing an amendment to?
No, deletion, sir.
Deletion of 67,
deletion, yes.
subclause 2.
Yes, subclause.
Attorney General.
Yes, sir. Just for the record, in the House, the debate included, coming towards the end, the Leader of the Opposition indicating that the Senate would pick up certain concerns as and when we got to the Senate, and I did undertake to look at any concerns when they came to the Senate. That was 8 days ago, when we sat in the Senate then, in the House of Representatives. After that, we had the benefit of sitting in this House for the debate for 2 days, and then we have sat in committee for 2 days, and we have welcomed the suggestions coming from the senators sitting here this afternoon. We understood that, of course, the amendments would come to us in written form because there's been ample time for that. So just for the record, they not having come, other than that ending with section 40, clause 43.8 from the opposition, that is the reason why we couldn't guess what the opposition would come with. In any event, with respect to the deletion of 67.2 as proposed by Senator Mark, we think it important that there is an enforcement attachment potential, which is what 67.2 does. 67.2 treats with that particular response, and we think it is a necessary feature of the legislation.
So, Senator Mark, what I will do now, so I'll put the question on clause 66, dispense with, and then on 67, Senator Mark, a proposed amendment, and then we'll move forward as such. So, Honourable Senators, the question is that clause 66 stand part of the bill. Honourable Senators, the question is that clause 66 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 66 now stands part of the bill.
Clause 67.
Honourable Senators, the question is that clause 67 be amended as indicated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. I think the noes have it. Honourable Senators, the question is that clause 67 stand part of the bill. Honourable Senators, the question is that clause 67 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 67 now stands part of the bill.
Mr. Chairman, again, just for and ensuring that our language is clear. Through you, I'll ask the Attorney General if he goes to 67 sub 3, 4 rather, no, is it 67 3? 4, 67 4. This word exercisable, Mr. E.G., is it enforceable or is it exercisable? What are we trying to say here? Just for clarification.
It'll be read in the context of enforcement. So it may be exercised or enforced. So they're synonymous.
It doesn't matter if it's exercisable or enforceable.
Yeah.
Okay. You're happy with the language as it is?
Yes, sir.
Okay, thank you. Thank you, Mr. Chair.
Okay, so Senator Mark, just in the interest of time as well. So when you indicate that you have an amendment on a particular clause within a batch, if you also see clarification, just indicate as such and put it all in one so that it could be dispensed with so we don't have to keep re-putting the question. So I'll put the question again. No? Okay, all right.
Part 6, clauses 68 to 70.
Honourable Senators, the question is that clauses 68 to 70 stand part of the bill. Honourable Senators, the question is that clauses 68 to 70 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 68 to 70 now stands part of the bill.
Part 7, clauses 71 to 73.
Honourable Senators, the question is that clause 71 to 73 stand part of the bill. Honourable Senators, the question is that clause 71 to 73 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 71 to 73 now stands part of the bill.
Part 8, clauses 74 to 76.
Honourable Senators, the question is that clause 74 to 76 stand part of the bill. Senator Mark, you want to identify the particular clauses that you have an amendment to?
I will, sir. In terms of clauses 75,
75,
and 76.
75 and 76.
75, 75, sub.
So, Senator Mark, let me just, given that indication, let me just put the question for 74 one time.
Okay, thank you.
Clause 74.
The question is that clause, you have
yes, I have a query on
amendment
74.
or query?
I don't know, it could be a potential amendment for the AG.
For 74.
For 74. Attorney General, on the third line of 74.1, it spoke of experts. I don't know if you want to use the same formula that you used back, I believe, in the section that we dealt with, that dealt with consultants and the other officers that were specifically named, that falls as staff under the agency.
It should be under 19. Agency may engage experts, advisors, and consultants.
So we'll have to even change the reference to the section. There's no 18.2.
1 second now.
So it will be 19.2.
Yeah, that's correct. And I think it's advisable to add those species of
The other
of persons.
categories,
Yes, including experts.
advisors and consultants.
Yep. Advisor, yeah. Well, it really should be advisors, experts, or consultants. So if you put advisors before experts, advisors, then comma, experts, or consultants, and forgive me, and consultants, and that 18.2 should be 19.2.
Yes.
So change 18 to 19. Thank you.
May I, Mr. Chairman, before you put the question on the same one, just
Okay.
Attorney General, in subsection 3,
Yeah.
I would like to propose an amendment that the summary conviction for those persons who breach confidentiality, the fine is too low. I'm proposing 500,000 and 15 years in jail. And secondly, on conviction on indictment, $1 million and 20 years in jail. Because this is very serious business. And you remember, all these employees are on contract. So you don't know what they will do, and what they will not do.
Under the conflict of interest, we already have fines for 500,000, Section 19.
And Mr. Chairman, if you look at Section 19 of the bill, you'll see with conflict of interest, the kind of fines that is being proposed as well. So I just want the AG to be consistent. And remember, Mr. Chairman, in terms of 60, if somebody willfully provide wrong information, it's $100,000 and 20 years in jail, you know. So I just want the AG to consider consistency here.
Yes, Mr. Chairman. So the cross-reference, if I may just ask again, is to 19 which aspect of it? The offense which was created with respect to breach?
Do you want conflict of interest?
19.
Sub 5, 19 sub 5, with conflict of interest.
So it's subclause 7, so to a fine of $500,000 and imprisonment for a term of 5 years.
And then when you go to 60, clause 60, anybody who willfully and recklessly and knowingly does something contrary in terms of declaration is $100,000 and 20 years in jail. So we just believe that there should be consistency. Some of the amendments, Mr. Chairman, do I deal with my amendments now?
So, yes, 75, yes, I'll treat with 74 first.
First, okay, and then, okay, thank you.
Mr. Chair, I think that consequent upon this discussion, that subclause 3 of section 74, clause 74, should firstly be amended in the third line of clause 74, subclause 1, as it appears at page 61, after the word including, insert the word advisors, comma, and then after the word experts, insert the words and consultants. In the fourth line, delete the word 19, 18, and insert instead 19. In subclause 3, insert after the word who in the third line the words recklessly or knowingly, and in subparagraph A, delete the word one and insert instead two, and insert after the word 100 the word 50 and 50, forgive me. In subparagraph B, delete the word one, insert the word 5, and delete the words and 50. And then delete the word 5 and insert the word 7. So subparagraph 3 should read in full: a trustee, the property manager, employee of the agency, or any person concerned with the administration of the Act who recklessly or knowingly discloses documents, information, or any other matter relevant to the administration of this Act in contravention of this section commits an offense and is liable, A, on summary conviction to a fine of $250,000 or to imprisonment for 5 years. Yes, so I'm now saying delete the word 3 and insert the word 5. And on conviction on indictment to a fine of $500,000 and to imprisonment for 7 years. Now, we have looked at this against clause 19 as Senator Mark referred us to it, and the difference between the two, the difference in treatment, is occasioned. We had a chance to look at the Integrity in Public Life Act to see what the prescriptive offenses there were. There being a difference, I think, logically between benefiting from a conflict of interest as opposed to a disclosure which is protected by the aspects of sealing of documents which we have already put inside of the bill elsewhere.
Mr. Chairman, if I may ask for further clarification from the Honourable Attorney General. Attorney General, if we go to clause, and Mr. Chairman, if you'll allow me, because it's connected, if you go to clause 60 of the bill, Mr. Honourable Attorney General, can you justify why if somebody makes a mistake knowingly and recklessly or willfully, why are we putting away that person for 20 years and 100,000, but somebody who give my private information to other person that ought not, they get 5?
Sure.
I don't understand the disproportion.
So in clause 60, by way of comparing it to clause 74, 60 is the declaration which you give to the court, which is the springboard from which the unexplained wealth order can happen. And you'll note that in clause 60, we're saying knowingly and willfully. We're not including recklessly, because people may make an innocent position which, even though reckless is not innocence, it is certainly of a lesser type than knowingly and willfully. So we've gone with a higher mental intention in clause 60. And because this is the launching pad to tell you to come forward and tell the truth in the unexplained wealth order, we've sought to penalize this in a larger fashion. When we come to clause 74, the issue of secrecy, we are providing, because these documents are inside an ecosystem, as Senator Vera usefully coined that phrase in the context of this bill, because they're in an ecosystem and there may be reason for the information to pass amongst people who have the oath of secrecy or even to the court or expert advisors, the risk of disclosure of that information becomes quite significant. Look at cabinet minutes and notes. They're all secret and confidential, and the Freedom of Information Act prescribes against their disclosure, subject to the public interest equations, etc. So I think it appropriate to have treated this in a slightly lesser category than the knowing and willful breach of the underpinning of the Unexplained Wealth Order Declaration.
Senator Vera.
Thank you. No, AG, thank you, because I'm much more comfortable with this crafting that you have done than it was before, or with Senator Mark. Just to give Senator Mark some additional comfort, these are penal provisions, and the way it was originally cast was a strict liability offense, and a person could disclose accidentally and then still find themselves running afoul of this act, because you think you're giving it to one person and the envelope is mistakenly given to somebody else. But the other thing I wanted to say is, a person who has suffered because of a disclosure also has the right of a civil redress action against the agency. This fine doesn't put anything in the victim's pocket. And so you want to leave a little kakada for the...
May I just add one further amendment, please, Mr. Chair? In subclause 3A, you'll note that there is the word or. This is the summary conviction. It should be and. So instead of the word or, in 3A, you'll see delete the word or after the word dollars.
Right.
And put the word and instead.
Okay.
To keep it in
Senator
sync
Mark
with B.
and Senator Hussain.
And thank you for the
If I'm following correctly, I think what Senator Hussain had proposed was incorporated. Senator Mark, to some extent, the Attorney General incorporated what you were indicating. So I'm assuming the proposed amendments that you were putting forward are withdrawn, so that I can...
Oh, no, only for 74.
Yes, for 74.
Yeah.
74 is what we're treating with.
Yeah, okay.
Right, so I'll put the question. The question is that clause 74 be amended as follows. At sub-clause 1, after the word including, insert the following: advisors, comma. After the word experts, insert the words and consultants. After the word section, delete the number 18 and insert the number 19. At subclause 3, after the word who, insert the words recklessly and knowingly. Or recklessly or knowingly, sorry. At subparagraph A, delete the word 1, insert the word 2. After the word 100, insert the words and 50. After the word dollars, delete the word or and insert the word and. And after the word 4, delete the word 3 and insert the word 5. At subparagraph B, delete the word 1 and insert the word 5. After the word 100, delete the words and 50. And after the word 4, delete the words 5 and insert the word 7. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 74 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 74 as amended now stands part of the bill.
Clause 75.
Honorable Senators, the question is that clause 75 stand part of the bill. Senator Mark.
Yeah, Mr. Chairman, I would like to, because of the serious nature and the fact that this, as the Honorable Attorney General said, it's novel, and you want to ensure that at first go, we have as much protection, right? And it involves people's properties. And I don't think, Mr. Chairman, that we can escape the need for 75(2) to be subject to an affirmative resolution of Parliament. So I am suggesting, because of the nuclear nature of the legislation, that we need to really police as much as possible what is being done, what is being proposed in regulations to govern this piece of legislation.
The amendment, Senator Mark, is negative to affirmative, yes? Take out
Yes.
negative and put affirmative.
Yes.
Is that all on clause 75?
No, on clause 75, I go further in subsection 4. It is said in that section, notwithstanding 63 of the Interpretation Act, regulations under this section, which is section 63, may prescribe penalties for breaches of these regulations of up to $500,000. So new regulations are going to be made to deal with breaches. I am suggesting an amendment to that section. Regulations made under this section shall be subject to an affirmative resolution of the both houses of Parliament.
So the amendment is to delete may prescribe penalties for breaches of those regulations of up to $500,000 and insert the words.
Is it, well, first of all, Mr. Chairman, may I ask the Attorney General for clarification? Is the regulation in 75 3 or 2, I should say, is the same as in 75 4 that is being proposed, or are we talking about two different sets of regulations? One with the omnibus regulations, and the second set dealing with penalties, etc., etc. I believe they are separate, and that is why I propose two sets of regulations.
Attorney General.
They are one and the same, both regulations.
One and the same?
Yeah.
Okay.
And the regulations being subject to negative resolution are no different from the manner in which the rules of court are made, which are subject to negative resolution as well. This is also no different from the manner in which the Proceeds of Crime Act, which treats with certain property issues, are there. Now, I've referenced the rules of court by negative resolution because they too treat with prescriptive measures that affect property and rights on a daily basis. And if I take that as the golden standard, the Rules Committee rules, and the fact that they're done by negative resolution, we believe that this really ought to be done in this fashion. Secondly, the rationale for the variation from Section 63 of the Interpretation Act is that in default of varying Section 63, the regulations are confined to a maximum of $500 by way of penalty for breach of the regulations, and therefore have no persuasive effect by being proportionate to the kind of breaches, to the kind of offenses that ought to visit breaches.
Because of the novel nuclear nature of the proposed legislation, it is incumbent upon parliamentarians to do a kind of supervisory and perform a supervisory role over this institution. And it is against that background, I am really seeking to encourage the Attorney General for this piece of legislation to go with the affirmative so that we can all be exposed to those regulations and they will be subject to a debate in the Parliament rather than I have to come with a negative, with a motion to annul or not to annul as the case may be. So I believe that the AG would understand the importance of this legislation, and I would like him to reconsider his position on not going with an affirmative.
Senator Vera.
I totally get where Senator Mark is coming from, and ordinarily I would say absolutely yes. But when I look at the kind of regulations we are talking about, they're not quite nucleic. Storage, management and disposal, procedures for the exchange of information, designing forms. I think if it was something a little more invasive, I definitely would be supporting Senator Mark for affirmative, but I think I could live with negative on this one.
I assume responses.
Mr. Chair, I respectfully maintain the same position advanced earlier.
Honorable Senators,
Mr. Chair.
comments on what Senator Marcus said or something new
No,
in relation to
something new.
75? Something new?
Yeah. Attorney General, I see that in relation to subsection 3A and 3 Roman numeral 2, you've been very specific as to procedures for the storage of and for the management of, and then you have different types of property that are listed there. Having regard to the various range and the unlimited nature of the type of property that would be subject to these kinds of orders, don't you think that you should give yourself the power, well, not yourself, but the office, the power to have an omnibus provision after both sections so that what is not captured by the legislation, because while I speak, it's difficult to list all the different types of assets that should be, that can be caught by it. I just think that limiting yourself.
Understood. Fear of the ejusdem generis rule in operation, which is why we separated subclause 2 from 3. So we put 2 in general terms, and then we said specifically in 3, we wanted to point the office holder's mind to the matters which we have in 3. So that's why we did 2 standing entirely separate from 3.
It's the same provision. This is 3A you're talking about, Roman 1 and 2?
Yeah, and just to, for the record, I think that the most invasive law that we have, full stop, is the Interception of Communications Act. The most. And the regulations are negative resolution.
No, I'm
No,
not.
sorry, I was just referring to the previous point, just for the record.
But AGD, I thought the reason why you have separated Roman 1 from Roman 2 is because one deals with storage and one deals with management. That's why you have real property in 2 and not in A, and not in Roman numeral 1.
Sorry, I meant 1 to 3. Forgive me, not for 2. I apologize. So that's why I referred in 3 to 1. Forgive me, I was saying 2 and 1. It really was 75.1 and 75.3. So there's a generality of regulations provided for in section 75.1 without the ejusdem generis tail, and then subsection 3 provides for, notwithstanding the generality of 1, you may make regulations specifically for these matters.
Okay. So I will now put the question on Senator Mark's amendment first.
CPC is recommending, by way of improvement to section 75.1, that we can delete the words appearing in the second line at 75.1, delete the words anything required to be done under.
That's it?
Yes, sir.
Okay, so I'll put the question on Senator Mark's proposed amendments first, and then subsequently on the Attorney General's proposed amendments. So, Honorable Senators, the question is that Clause 75 be amended as proposed by Senator Mark. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. Honorable Senators, the question is that Clause 75 be amended as follows. At subclause 1, delete the words anything required to be done under. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 75, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 75, as amended, now stands part of the bill.
Clause 76.
Honorable Senators, the question is that Clause 76 stand part of the bill. Senator Mark?
Do I have one, sir?
You indicated that you did. If you don't, that's quite fine.
Did I indicate to you, sir?
Yes, you did.
When, sir?
Right here, 75 and 76 when I asked you in the batch. But again, it's not a
No, I wouldn't detain you, sir.
Honorable Senators, the question is that Clause 76 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 76 now stands part of the bill.
Mr. Chair, we had stood down.
Yeah, clause 73 revisited.
43.
Sorry, clause 43 revisited.
Yeah, and Mr. Chair, if I could indicate that we'd also, with your permission, like to revisit clause 14. I believe that Senator Ramdeen had an inquiry to that. I don't quite understand the scope of it yet, but I'd be minded to listen subject to your guidance.
So we'll revisit clause 14 first.
43?
And then 43.
Sure,
I'll
as you
take it in
please.
order.
Yes,
Clause
sir.
14 first and then 43. So, so Senator Ramdeen, you want to?
I'm obliged, Mr. Chair. Mr. Chair, in the, in clause 14, if you go to subclause 3 on page 14 of the bill, you'd see that one of the functions
Ramdeen?
yeah.
I assume
Sorry,
subclause-
2. So, sorry. Subclause 2, 3.
D Roman 3, right?
Is it D Roman 3? Is it?
To manage criminal property, including?
Yeah, C, at the top, C.
There's no Roman 3 in C.
No, not Roman.
I see.
14.2C.
14.2C. Yeah.
To incur expenditure for the
Yeah.
to incur expenditure for the purposes of acquiring any part of the criminal property or any interest in it. And what I was indicating, Attorney General, is that the criminal property here would be, you would be restricting yourself to criminal property when what it really should be is recoverable property, because as it is drafted here, it would exclude, sorry, that's the word, exclude terrorist property and instrumentalities of crime. And the same will occur for C2, Roman numeral 2, which is discharging any liabilities or extinguishing any rights
you're right.
to which.
Yeah, I think you're right.
So can I just point out all of them so that you
Yes,
can just take
yes,
them?
please.
So it'll be C, Roman numeral 1, C, Roman numeral 2, D, the heading of D, which is to manage, it should be recoverable property. Agreed?
Yeah.
Yeah, recoverable property, sorry, including selling or otherwise disposing of assets comprising the recoverable property.
And E, yeah.
D2, Roman numeral 2, where recoverable property comprises assets of trade. Roman numeral 3, incurring capital expenditure in respect of recoverable property. E, to sell recoverable property. Going too fast, Mr. Chair?
No.
Oh, sorry. E,
Same for F.
to F, same criminal to recoverable. G, recoverable.
Yeah.
H, recoverable. And I, recoverable.
G to add recoverable.
Mr. Chairman, I thank Senator Ramdeen for these observations. I think they're perfectly in order.
G2 don't need to be recoverable.
Sorry?
Yeah, we've got D1 as well, yes.
Every incident appears.
Clause 14.
Yep.
Honorable Senators, the question is that clause 14 be amended as follows. Where the word criminal appears, delete and replace with recoverable.
That's not
No?
entirely correct. If you were to say, you would say,
Okay.
where the,
I will go through one by one.
no, it's easy. You can say, wherever the word criminal appears in paragraph C through I inclusive, replace with the word recoverable.
C through I inclusive.
A C in 14.1, so it'll be where it appears in
14.2C. Thanks, that's
Yeah.
it, correct?
14.2
C through I inclusive.
inclusive. Okay, so the question is that clause 14 be amended as follows at subclause 2, C through I inclusive, delete the word criminal and replace with recoverable. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 14 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 14, as amended, now stands part of the bill.
Clause 43 revisited.
We've stood down. Attorney General?
Yes, sir. I'd like to thank Senator Thompson-Aye and the honourable senators that made the observations with respect to Clause 43. We propose that Clause 43 be amended in the manner circulated. We've had the opportunity to actually reduce it to writing. So in effect, we're amending Clause 43(3) such that what appears at subparagraph A goes up into the chapeau, so that it would read, if I read from the top of page 38, the property, the application for compensation shall be made within 3 months beginning dash. I'm just explaining what is circulated. So that A would be merged in that fashion before the word dash with subsequent deletions. And then what we would do is to tidy up 3A that is left there, deleting the words within 3 months beginning, because we put that into the chapeau. In 3C, we would insert after the words is granted the words with the date. So if you look at C, if the application is granted with the date, beginning, sorry, yeah, so beginning's up in the chapeau. So with the date, so if you were to read the chapeau with subparagraph B, it'll be beginning with, if the application is granted with, yeah, with the date on which, as circulated there. And then in subparagraph 3C, we're adding in, after C, or within such further period as the court considers just in the circumstances. That really forms a choiseul, a footer to it, so that all of them, A, B, and C, are read both in the context of the chapeau and the choiseul, the head and the foot, to make sense of the paragraph, which would take care of the concerns raised by Senator Thompson-Aye. In subparagraph 4, we're proposing to insert after the words the discontinuance, the words or within such further period as the court considers just in the circumstances. And then in subparagraph 6, we'll insert after the words that section, the words again or within such further period as the court considers just in the circumstances. So we allow for the enlargement of time in each of the respective circumstances that can trigger this event.
Okay, so just for a point of clarification, everyone has this circulated amendment by the Attorney General. I shall now put the questions. Honourable Senators, the question is that Clause 43, as circulated, be amended as circulated, by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 43, as amended, now stand part of the bill. Those in favour say... Attorney General, you have...
One of my colleagues slipped me a note, and I'm trying to figure out who that colleague is. Is it you, Senator Ramrat? Could I ask for Senator Ramrat to raise a concern that he may have?
Minister?
AG, I'm just asking, when we replaced criminal property with recoverable property, if we deliberately left it in 14(2)A, in the second line.
Yes, because we were dealing with the species there.
Right, okay.
So we had disaggregated criminal property from instrumentalities and terrorist property.
Sure, okay.
Yes, thank you, Mr. Chair.
Okay, so I'll start again just for accuracy for Clause 43, which is what we're dispensing with now. So the question is that Clause 43 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 43, as amended, now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 43, as amended, now stands part of the bill.
New Clause 43A.
Honourable Senators, the question is that new Clause 43A be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New clause 43A will now be read a second time.
New clause 43E.
Honorable Senators, the question is that new clause 43A be added to the bill. Those in favor say... All right. Senator Hussain?
Thank you very much, Chair, and the Senate for your indulgence for this new clause 43A and 57. Chair, I'll deal with the both because they both are the same clause. So basically, the reason why we're asking for this new clause to be inserted is so that...
Apologies, just we have to treat it one by one.
Okay, I'll just adopt the submission in the other clause.
So 43A.
With respect to this new clause that we are proposing to be added into the bill, the reason is that because persons will now be subject to disclosing their assets before the court, and we believe it might be more prudent that these hearings be closed, especially the orders made by the court, be sealed orders, because most of the sittings are in camera. We propose that the court orders be sealed so that it doesn't fall into the wrong hands, and also the persons who this order may affect, their reputation is also at stake here, Mr. Chair. And this is really to protect, one, the privacy of the person, keeping with the proportionality of the bill that the Attorney General would like to move forward. So these are the very short submissions based on this new amendment.
Mr. Chair, thank you for the opportunity before the Attorney General answers. I think that to tighten what Senator Hussain has presented, I think it should be all documents filed pursuant to an application for a property restriction order under this part, because it will contain documents will be filed before. You can have documents filed before the order is actually made, which is the restriction of property aspect of it. So that you would want to capture more so the documents that would be filed before and the documents that would be filed in answer to the application for the property restriction order. And you've already, in the unexplained wealth part of the legislation, you've already agreed, Attorney General, that it's in the best interest to have these proceedings sealed for the simple reason that, first, we can craft the amendment in such a way that the proceedings are sealed when filed and still allow the court to have the discretion in any event to treat with it to satisfy the principles of open justice, but leave the discretion within that of the court.
Sure. And there's one more. I think we could probably tighten a little further, because we have third parties who may file proceedings in these matters. So instead of saying by the applicant or respondent, can we say then by all parties, or all parties to the proceedings?
So just before the Attorney General responds, walk me through the proposed further amendments to your new clause 43A. So all documents filed pursuant to an application for property restriction order under this part.
Well, Chair, if the AG could respond first so that we'll know what the government's position is.
You have all the proposed amendments.
Yeah. Well, it's really, we're anchored now in policy and logic upon policy. We felt it prudent to include the restriction for publication by way of sealing in the unexplained wealth orders, which are a different part, because that really does involve access to sensitive personal information, which someone may be required to treat within a court of law to explain their positions prior to an unexplained wealth order being made. In the civil asset route, the civil asset forfeiture order route, which is under this part, via the trustee's application after the DPP's purpose, we very specifically require two things. One, notice to the whole world, so that anybody that has an interest in the property has a shot of knowing about it, and not just actual notice, but the constructive notice that happens by way of publication to the public, which is why in Clause 40 you see where the High Court has made a property restriction order, the order shall require the agency to give notice of the orders to public and private institutions publish the notice of the public restriction order in the Gazette and for 2 days in 2-week period for 2 newspapers in daily circulation in Trinidad and Tobago. So that publication requirement is intended to catch third parties, parties within the ambit of Section Clause 50 of the legislation, or persons who wish to exercise their rights to say this is not recoverable property within the context of Clause 7(9) of the legislation. The second reason why I would be slow to accept the recommendation is that under the Proceeds of Crime Act, Section 32 of the Proceeds of Crime Act in particular, there is no sealing of provisions. In fact, the only real restriction that we find on this type, which is an axiomatic restriction which comes in the order publication, really comes about in Norwich Pharmacal applications, where the purposes of the Norwich Pharmacal are only granted to limited persons entitled to see the orders. So if you wanted to get an investigative tool by way of a Norwich Pharmacal application in the civil route procedure, get someone's bank accounts without their knowledge, have a third party give it to you, the court only grants those orders in very limited circumstances, saying you cannot disclose this to anyone else. So there's an order which prohibits the publication, etc. To put that these records would be sealed in the civil asset route, not the unexplained route, we've sealed them in the unexplained route, would collide with the need for publication and notice to the whole world, because we're affecting property. It would reduce the proportionality argument, and it would be contrary to the existing law which we have, which has been recognized by the Privy Council as one of the proportionate rational reasons in legitimate aim, connection, minimum method of intrusion. But when you get to the fourth limb, the proportionality argument is really amplified by publication of these types, and it would collide with Section 32 of the Proceeds of Crime Act. So for all of those reasons, I think it respectfully imprudent to seal the records on this side of the equation, not the Explain Your Wealth side. That side is properly sealed.
You had a comment?
Yeah, I understand what you're saying about the sealing, and I agree. But I think there may be a way in which we can protect citizens' information going out there. In the Matrimonial Property and Proceedings Act, there is a restriction on publication of reports of judicial proceedings. So maybe that could be something that at least we could achieve by saying, well, look, you cannot, because you can't just go to any court file now and access it. So if we could put in there something along those lines where...
the anonymization, but then again, at this stage, the anonymization, now, let me accept the point immediately. In the United Kingdom, the leading case on unexplained wealth orders involved the court volunteering to do an anonymization order by way of an application from the parties to the litigation. So it was done by way of the parties asking for the anonymity to prevail. We're colliding here now with the need for the public to know, because there may be proprietary rights which third parties have, versus the anonymization. And sometimes people don't ring a bell in their mind until they know a little bit more than that.
So the reason why I went to matrimonial is because it wasn't carte blanche. There was a range of permitted reporting. This is an important point because I think, again, you're balancing.
But we did that by rules of court, as I squarely remember.
Right.
There was a time when there was this very stellar judgment produced by Madam Justice Miradine Armorer, for instance, which every lawyer who was in the matrimonial court went to, and all the parties' names were there, and it was online. It was the judiciary's own discretion to exercise anonymization of records that caused that to change, and it was not in the primary legislation.
Mr. Chair.
Senator Mark.
Attorney General, because the threshold is extremely low in the civil assets forfeiture portion of this legislation, on the balance of probabilities and on reasonable suspicion, we could be damaging irreparably the reputation of innocent citizens in Trinidad and Tobago. And because this is limited property rights and privacy and enjoyment of property, I am wondering what harm unless there is some political mischief afoot. What harm would it bring to our Parliament if, just as how we did for the unexplained wealth, you seal these proceedings rather than have people names dragged through the mud in Trinidad and Tobago? Because what you are saying, Mr. Chairman, is that once you go that route, this thing is going to be in the newspapers, it's going to be gazetted. This, and I'm telling you, Mr. Chairman, and I want to advise this AG very carefully, because you see, sometimes your intentions might be good, but how you proceed might be very bad. And I would like the Attorney General to reconsider his position, because why the inconsistency? Why for the unexplained wealth orders, you have one position, but when it comes to the civil asset forfeiture provision, you have another
Senator
position.
Mark, understood. The Attorney General did respond, unless the Attorney General has final comments on that position. I want to believe that
I've explained it comprehensively. There's a material distinction between the two, and we can't, as a matter of policy, agree to it.
At this point, Senator Ramdeen, there has been quite a bit of discussion on this new clause 43A. What I want to do is just to make sure I get the amendments, or whether Senator Hussain is proceeding with the amendments that you're... Great. So could you call out the amendments to me so we get it? I got after pursuant to an application for a property restriction order, but you also said something after the. So by the.
And under this part, just 1 second, all documents filed pursuant to party.
By all parties. So delete applicant or respondent and put in by all parties. The applicant or respondent by all parties. Pursuant to an application for a, okay.
Chair, and we'll also delete the words from pursuant to the word order.
So you're deleting pursuant to a property restriction order?
Yeah, so it reads, all documents filed under this part by all parties shall be sealed by any party
Shall be
sealed by the court office until further order by
any
the
or all parties? Any?
Any party.
Okay, so new clause 43A as amended reads, all documents filed under this part by any parties shall be sealed by the court office until further order by the court, yes? Yes? All right. Honorable Senators, the question is that new clause 43A as amended be added to the bill. Those in favor say aye. Aye. Those against say no. No. I think...
Mr. Khan?
No.
Mrs. Gopi Schoon?
No.
Mrs. Batiste Primus?
No.
Mr. Rambarat?
No.
Mr. Sinanan?
No.
Mr. Hussain?
No.
Ms. West?
No.
Mr. Lehant?
No.
Dr. Henry?
No.
Mr. Singh? No. Mr. Cummings?
No.
Mr. Dookie?
No.
Mr. Young?
No.
Mr. Thomas?
No.
Mr. Boris?
No.
Mr. Mark?
Yes. Yes.
Ms. Haynes?
Yes.
Ms. Amin?
Yes.
Mr. Hussain?
Yes.
Mr. Ubika?
Yes.
Mr. Ramdeen? Oh, you want, okay. Mr. Richards?
Yes.
Ms. Chut Essie?
Yes.
Mr. Vera?
Abstain.
Dr. Dial Singh,
Yes.
Ms. Dunarang,
Yes.
Ms. C. Prasad,
Yes.
Mr. Timal,
No.
Mrs. Thompson Ai,
No.
Dr. Dylan Remy,
Yes.
Honorable Senators, the results of the division are as follows: 11 for, 17 against, and 1 abstention. The question that new clause 43A as amended, now stand part of the bill, is not approved.
New clause 57E.
The question is that new clause 57A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it.
We win it.
Attention, I'll put the question again, just for proper procedure and again, accuracy in reporting. The question is that new clause 57A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it.
Schedule 1.
Honorable Senators, the question is that Schedule 1 stand part of the bill. Honorable Senators, the question is that Schedule 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Schedule 1 now stands part of the bill.
Schedule 2.
Honorable Senators, the question is that Schedule 2 stand part of the bill. Senator Vera.
Sorry, Chair. I had raised with the AG a point on Form 1. The name of declarants dependents, but the way the form is, it only lists children. And as we had said in the course of the debate, a dependent could be an ailing aunt, a relative, it could be wider. So I was wondering whether, because the forms...
We could delete the word child.
Just say dependents and then you could state the relationship.
Yep. So what we can do is to delete the word child and instead put the word, well, delete the words dependent child and instead put dependents wherever they appear.
Attorney General, you agree to the amendment?
Oh, yes.
Yeah,
Okay.
for dependent children.
Is children.
Or child or children.
Dependents, it'll include the child and aged or infirm or others. Wherever they occur. Delete the words dependent child and replace with dependents wherever they occur.
Okay. So, Honorable Senators, the question is that Schedule 1 as amended.
Schedule 2.
Schedule 2?
Yes.
Schedule 2. I thought he said Schedule 1 or Form 1. Okay. Honorable Senators, the question is that Schedule 2 as amended.
No, be amended.
Be amended to remove the word dependent children where it appears and replace with the word dependent child
Dependent child.
where it appears and replace with the word dependents.
That's correct.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that Schedule 1 as amended now stand part, Schedule 2, sorry, as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Schedule 2 as amended now stands part of the bill.
Schedule 3.
Honorable Senators, the question is that Schedule 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Schedule 3 now stands part of the bill.
The president was educated in North America, Senator Thompson.
Honorable Senators, I now refer to the Honorable Senators, I now refer to the list of amendments as circulated by Senator Mark in relation to the new preamble. I'm assuming Senator Mark is still pursuing that.
But of course, sir.
Right.
This is my nuclear weapon. This is my nuclear weapon. You talk about nuclear weapon. This is my nuclear weapon. Mr. Chairman, would you like a...
No, one moment. Just 1 moment. Honorable Senators, in relation to the proposed amendment by Senator Mark on the preamble, I deem this proposed amendment to be out of order as it relates to Standing Order 68.3B. It is inconsistent with previous clauses agreed as it seeks to introduce a special majority provision when the previous clauses approved by the Senate did not require such a provision. So the ruling is that that particular amendment as proposed for a new preamble is out of order and therefore will not be proceeded upon.
Chair, can you just, what is the standing?
68.3B.
68.3B.
Honorable Senators, the question is that the bill, as amended, be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill, as amended, will now be reported to the Senate. Members, I'm back in my chair. Members. Senator Amin.
Mr. Chairman, you had indicated us that we would treat that at the end of the meeting. I don't know if you're going to treat it before. We treated it? No, we didn't know the committee. When we raised that, you told us that. And then they tell us at the end of the meeting.
Senator Mark, please.
That's serious matter, sir. Very serious matter.
Attorney General.
Mr. Vice President, I wish to report that a bill entitled An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the Recovery of Criminal Property through the use of the remedies of restriction in dealings with civil asset restriction and forfeiture of criminal property and the management of criminal property and unexplained wealth orders and matters incidental thereto was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the Recovery of Criminal Property through the use of remedies of restriction in dealings with civil assets restriction and forfeiture of criminal property and the management of criminal property and unexplained wealth orders and matters incidental thereto. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. Vice President, I beg to move that a bill entitled An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the Recovery of Criminal Property through the use of remedies of restriction in dealings with civil assets, restriction and forfeiture of criminal property, and the management of criminal property and unexplained wealth orders and matters incidental thereto be read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the Recovery of Criminal Property through the use of the remedies of restriction in dealings with civil assets, restriction and forfeiture of criminal property, and the management of criminal property, and unexplained wealth orders and matters incidental thereto be now read a third time and passed. Those in favor say aye. Aye. Those against say no.
Division, Mr. Vice President.
Mr. Khan?
Yes.
Mrs. Gopiskun?
Yes.
Mrs. Batiste Primus?
Yes.
Randy walkout.
Mr. Rambert?
Yes.
Mr. Sinanan?
Yes.
Mr. Hussain?
Yes.
Ms. West?
Yes.
Mr. LaHunt? Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Cummings?
Yes.
Mr. Duki?
Yes.
Mr. Young? Mr. Thomas?
Yes.
Mr. Boris?
Yes.
Mr. Mark?
Yes. We said we were going to.
Ms. Haynes? Ms. Amin?
Yes.
We can sustain it, AJ. We can sustain that.
Mr. Hussain?
Yes.
Mr. Obika?
Yes.
Mr. Richards?
Yes.
Ms. Chuk?
Yes.
Mr. Vera,
Yes.
Dr. Dialsing,
Yes.
Ms. Deodorant,
Yes.
Ms. C. Prasad,
Yes.
Mr. Timal,
Yes.
Mrs. Thompson, aye?
Yes, sir.
Dr. Dylan Remy,
Yes.
29, right? 29?
Yep.
29 and 4. 29, 4.
Senator Mark, Senator Mark.
Sorry, sir. Happy Easter, sir. We have done it.
Honorable Senators, the results of the division are as follows. 29 for, 0 against, and 0 abstentions. The question that the bill be read a third time is approved.
A bill entitled An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the Recovery of Criminal Property through the use of the remedies of restriction in dealings with civil asset restriction and forfeiture of criminal property and the management of criminal property and unexplained wealth orders and matters incidental thereto.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, I beg to move that this Senate do now adjourn to a date to be fixed.
Honorable Senators, before I put the question on the adjournment, leave has been granted for one matter to be raised on the motion of the adjournment of the Senate. Senator Mark?
Yeah, I want my colleague. You're under some pressure. Mr. Vice President, in the interest of the Holy Week, I didn't consult with my colleague in the front nor in the back, but I wanted to pursue a matter on emotion for the adjournment. But having regard to the length of time that we have been here this evening, I bow to my other colleagues who will bring greetings, but I will not pursue my motion this evening.
Senator Mark, your commentary is duly noted and recorded. Honorable Senators, I now invite you to bring greetings on the occasion of Easter. Minister of Trade and Industry.
Thank you very much. Last Sunday, Palm Sunday, we recall Jesus' triumphant entry into the city of salvation, Jerusalem, and this marked the beginning of Holy Week. On Thursday coming, Christians will begin to take part in the liturgical ceremonies of the solemn Easter Triduum, sharing in the final hours of Jesus Christ's earthly life, our Lord's crucifixion, death, and resurrection. And as Christians, we undertook a journey of preparation over the Lenten period, reflecting on creation, on the destructive power of sin, and above all, the healing power of repentance and forgiveness. Colleagues, God's love and mercy are real, and we welcome Christ's victory over sin and death into our own lives. Colleagues, Easter is not a weekend, but a season, a period of 50 days leading to Pentecost, a season of grace and a time of joy and thanksgiving. Beyond the religious festivities, Easter is for all a most wonderful time of the year, with good weather, blooming flowers, and with kids looking forward to the Easter bunny and Easter eggs. On behalf of the government bench, may I wish each and every one of you, and you as well, Mr. Vice President, and to all your families, a most happy and holy Easter. And may God continue to bless us all and our beloved country, because he reigns. Thank you.
Senator Ramdeen.
Mr. Vice President, thank you. It is a privilege on behalf of the Leader of the Opposition and the members of the opposition bench in the Senate to bring Easter greetings to Trinidad and Tobago. The celebration of Easter, Mr. Vice President, is really encapsulated in the scripture that says, "For God so loved the world that he gave his only begotten Son, that whosoever believeth in him shall not perish but have everlasting life." And we as Christians, for the last almost 40 days, started our Easter with Ash Wednesday, where we were reminded on Ash Wednesday that remember you are dust, and to dust you shall return. And for 40 days post, we celebrate our Lenten season with prayer, fasting, and repentance. And we come to this week that we refer to as Holy Week, which begins with Palm Sunday and the celebration of Jesus coming into Jerusalem. And the significance of Easter to us Christians, Mr. Vice President, it really represents the foundation of our religion. It represents the greatest act of love that one can identify with, because God gave, through the celebration of Easter, gave his Son to save the world and to save us from sin. And in the Easter story and the celebration of Easter, throughout the 40 days, and most importantly, through Holy Week, there is a lesson for all of us to be learned in every aspect of the celebration of Easter. There is the aspect of Jesus in 7 days being proclaimed, and the triumphant celebration of him coming into Jerusalem with palms being put on the ground. And in less than a week thereafter, the same people who were placing the palm leaves on the ground were asking for Barabbas instead of Jesus. And when we celebrate Holy Thursday, Glorious Saturday, and Easter Sunday, you have us celebrating the Passion of our Lord, going through the suffering that represents, for us who are Roman Catholics, it represents the sorrowful mysteries that we signify and the glorious mysteries that we celebrate. And the real celebration of Easter, Mr. Vice President, for all of us, is that it represents the triumph of light over darkness, which is represented throughout all our religions. And it represents the fact that, like I said before, God gave to us, his Son, to go through that passion, to carry that cross, to be crucified, and to then rise from the dead, so that we will all understand that we can all benefit from everlasting life in the life hereafter. To Trinidad and Tobago, on behalf of the opposition, Mr. Vice President, I want to say that the significance of what we go through during our Easter celebrations is something that each and every one of us can associate with. We all have our crosses to bear. We all have people in our lives, like Simon of Cyrene, who will help us carry those crosses. We all go through the suffering of our own individual passions. But what we must not ever lose sight of is that no matter how much darkness we may encounter in life, there is always the light of the world, that resurrection, and we must always never forget that sacrifice that God made for us to save all of us from sin, so that we can all enjoy everlasting life. On behalf of the opposition, all of my members on the opposition bench, to all of the members of the government, and to all of the members on the independent bench, and to you, Mr. Vice President, and to Madam President in her absence, and to the members of the parliamentary staff, the police, the protective services, and all of the citizens of Trinidad and Tobago, I wish to extend a happy, holy, and safe Easter to all of you. Thank you very much.
Senator Sipasad.
Mr. Vice President, in a few days, the Easter weekend will be with us. At this time, the period of Lent comes to an end, and Christians who are observing the Lenten 40-day period will have the satisfaction of the reward of their sacrifice in a symbolic relationship with the teachings of Christ. Easter also serves to remind us of God's graces, such as unconditional love, compassion, and understanding. On this weekend, Christians will also spend time in church following the Stations of the Cross as Christ is led to his crucifixion. The symbolism and message are universal in that faith conquers all, and even in death there's hope. Others look forward to the long holiday weekend to spend with friends and family. In family traditions, there may be an Easter bunny, Easter decorations, vision in a glass, lots of chocolates, and the simple meal of salted salmon and provisions. Whatever senators choose to be involved in, it is my honor to bring Easter greetings to this honorable House and to Trinidad and Tobago on behalf of all of us on the independent bench. May you find hope, health, love, and faith in God. Happy Easter.
Honorable Senators, I also wish to join with you in bringing greetings to the Christian community and the nation on the celebration of Easter. A commemoration of the death and the resurrection of Jesus Christ, resulting in the fulfillment of God's promise to us. The events of Easter lead us to realize that he so loved the world that he gave his one and only Son, that whoever believes in him shall not perish but have eternal life. The celebration of the resurrection of Jesus Christ is the most important day in the Christian calendar, as it embodies not only the message of love, but one of hope and renewal of life. As such, we must all strive to show love to one another as Jesus Christ and God loves us. It is through the repetition of the simple act of passing love on that we can truly reach our full potential. It is this capacity for love that God placed his faith in us, and the realization of his that we put ours in him. To the Christian community and all of Trinidad and Tobago, I wish you a holy and happy Easter, and may God continue to bless us all. Honorable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now adjourns to a date to be fixed.